Let's bring in James Trusty, a former DOJ prosecutor. Wanted to have you listen to Trey Gowdy, the congressman from South Carolina, about this raid on Michael Cohen's offices. Take a listen.
Sure.
We know that it requires the highest levels of DOJ permission to seize attorney-client records. And by that, I mean the Attorney General or the Deputy Attorney General. And we also know it must have nothing to do with Bob Mueller's probe, either directly or indirectly, or he would not have referred it.
Also, James, if I could run through this with you, former prosecutor Andrew McCarthy, who has written a lot about this case for National Review, writes, clearly the prosecutors regard Trump and Cohen as potential co-conspirators. It is important to bear in mind a distinction from the Russia investigation. This is not a counterintelligence matter. The SDNY is unquestionably conducting a criminal investigation, and a federal judge would not have authorized search warrants absent finding probable cause that federal crimes may have been committed. Wanted to get your take, James, on how unusual is this hearing that's being held just a few blocks away from our studios?
Yeah, the hearing is very unusual. Most of the time, if you're going to be challenging a search warrant, it's going to happen after you've been criminally charged and you file pretrial motions that allow for all sorts of constitutional challenges or other challenges to the case. So they were able to get the judge's attention, which is pretty impressive in terms of filing this show cause motion. But whether they're going to actually succeed in creating a new process for the review of potentially privileged materials, I think, is unlikely.
Can you walk us through this issue of the filter teams, also known as clean teams or taint teams? What is that all about, and how does it work?
Sure. Well, a filter team is basically just a process that's set up by the investigators, by the trial team of prosecutors, and by their agents to essentially safeguard themselves from any recusal. They send the materials to neutral folks that have nothing to do with the case. Those people review it to determine whether there might be privileged materials, and they will then kind of shepherd that to a judge for permission slips to either use or not use. So the point of all that is to keep the trial team from getting to a position where they've looked at something that's privileged and they get kicked off their own case. It's a pretty well-established process for DOJ. It's not really a constitutional requirement, but it's been something that has been used in practice for many years, and it's been approved of by courts in New York frequently. And
then you talked about, when we spoke earlier today, that you see some daylight starting to happen between Mueller's investigation and the rest of this. Can you explain?
Well, I think there's an interesting issue. You know, Paul Manafort filed a motion to basically challenge the scope of the independent counsel, and I thought that was a fairly routine motion and one that wasn't really going to win. But I think there's a bit of an evolving issue, which is whether or not there's too much closeness. If the independent counsel team is making referrals, which is, again, is based on the limits to the scope of their investigation, but still really participating or at least obtaining information that helps them build their own case. So it may be that SDNY and the independent counsel have completely separated once the referral was made. But if I were in the mix representing Mr. Cohen, I'd sure be exploring whether or not SDNY is basically a bit of a stalking horse for the team Mueller and obtaining information that goes back to the Mueller team.
That's certainly a question. Laura Ingle, in her report, said that Michael Cohen today was asked by the judge to give a list of clients, and Michael Cohen provided 2 of 3, President Trump and Elliot Broidy. The third one wants to remain anonymous. Is that in Michael Cohen's best interest, and is it sustainable?
Probably not in his best interest, and because it's fairly new territory, I don't want to say it's completely unsustainable. I mean, the reality is what the judge, I think, is doing is assessing the scope of how much material is going to be out there, but also letting the filter team or whoever it's going to be that does it understand their search terms, understand what is it that they're looking for that might trigger a claim of privilege. So if you leave out a client's name, then there's a much greater chance that the filter team will recover and review materials that might have otherwise been privileged. So it's a little bit against his interest not to identify the person, but I imagine he's got some sort of
probably
real
has a good reason
to
try to. A last question. We don't have that much time, but I did want to ask you, everyone's talking about James Comey's book. He's also a potential witness in the Mueller investigation. Do you think, from your experience, that James Comey might have, tampered his own witness shield in providing this book?
Well, I'll put it this way. I don't think any prosecutor wants to put a witness on the stand that publishes a book about their testimony. There's room for problems from that, just from that very fact. But in the grand scheme of things, and this is probably a little bit of a naive or romantic notion by me, I would kind of hope that FBI directors wouldn't typically want to do kiss and tell books. So no matter what the president said or did, no matter what Comey's feelings of being a victim or not, the idea that a law enforcement person at that high level writes these types of books is a little bit disturbing to me. So I don't know if that's direct to credibility, but it's certainly a factor in terms of assessing him. That said, I don't think there's going to be an obstruction case that relies on Mr. Comey to be a star witness anyway.
All right. Well, we love having you on the show. Thanks, James Trusty. We'll be back in touch.